Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is continuing on in the series of the 3 most dangerous lines to leave blank in a real estate contract. So today is the third one, and the third one is the due diligence period time frame. The other 2 were the binding agreement date and the time frames for the contingencies, especially the financing and appraisal contingency. But today I just want to briefly talk about why it is extremely dangerous to leave a blank in the due diligence time frame or the buyer's right to terminate time frame, as it is called in the RE forms contract package. So we are in April, May 2022, an extremely competitive real estate market. And I completely understand that a lot of buyers, in order to make their offer competitive and try to entice a seller to choose their offer over another buyer's offer, are doing all kinds of things. And one of those issues that they are doing is to put in 0 days due diligence. I understand that that is a competitive strategy. Please note there are a lot of other competitive strategies. I am strongly encouraging you or indicating why it is dangerous to put 0 days in for due diligence or buyer's right to terminate. So what is that? That is a buyer's right to terminate. Now, during the due diligence period, there are a lot of things that a buyer will do to help that buyer make the decision if they want to continue on with the contract or terminate. It is termination rights for a buyer for any or no reason. A buyer may terminate. They don't have to state a reason. They can just state that they are terminating the contract based on their right to do so as granted to them by the seller per the due diligence period. I encourage you to, at the very least, even if a buyer is using that as a strategy to be competitive, to at least put 1 day time frame in there. And sellers, I encourage you guys to a 1 day due diligence period for a buyer. If you are receiving a multiple offers and you are choosing, and everything else looks good except for they might have more days due diligence, I encourage you that 1 day off the market, all those other interested buyers more than likely will not have already chosen another property. So if the buyer that does have a 1 day due diligence period does terminate, you still have plenty of options as a seller to go back to those other offers, those other buyers that did indicate their interest in your property. Now, you buyer's agents, the reason I am encouraging to at least put 1 day, as I mentioned, this is an extremely competitive real estate market. And we have a lot of buyers that are experiencing losing out contract after contract after contract after contract. Purchasing a home may be an extremely emotional time and experience anyway. And when a buyer has experienced the disappointment of continually losing out on contracts, they end up almost potentially tying themselves up in a frenzy, like, let me just get what I can get. Well, the issue is, if a buyer, I encourage you to put at least 1 day due diligence time frame in there so that a buyer may sleep on their decision and perhaps terminate the next day, or terminate within prior to 11:59 p.m. on the next day, if they kind of catch their breath a little bit and really evaluate their decision. Sellers, this is good for you too, because the ultimate goal is to sell the house. And if a buyer at a later point in time does feel the emotional crunch and does decide that this is not the house for them, you also as a seller have wasted time off the market to sell to another buyer. So at least put in 1 day, if not more, to give your buyers the opportunity to sleep on it. And the issue comes down to, what about earnest money? Well, there are some buyers or some agents that mistakenly think that if a buyer terminates a contract prior to their obligation to have remitted earnest money, that the buyer just gets to keep their earnest money. That's not the case. If earnest money is addressed in the creation of a contract, it must also be addressed in the termination of a contract. Earnest money, it's not the consideration, but it is still part of the deal, regardless of where it is physically. So if a buyer states that they are putting in X amount of thousands of dollars for earnest money and it is due, they have agreed that they will remit those funds to the seller, let's just say 3 days after binding contract. If they have 0 days due diligence and the buyer terminates that contract, let's say 1 day later, they still owe that. They are still now in default of the contract. And even if they have not remitted those funds to the holder, they are still in default of the contract. And not only do they owe the seller that earnest money as liquidated damages for the default, the seller's broker and the buyer's broker, for that matter, may also pursue the defaulting buyer for commission that would have been earned. So don't think that not sending in the earnest money is a protection for a termination of a contract with 0 days due diligence. It is not. And in this market, we are experiencing a lot of sellers as well as brokers that are pursuing defaulting buyers for the earnest money when they are using it as a strategy to put in 0 days due diligence, not sending in the earnest money, and then terminating by default because they didn't have a right to terminate because they had 0 days due diligence. We are having a lot of sellers pursuing buyers for that earnest money, and we are having a lot of brokers pursuing defaulting buyers for the commission they would have earned had that buyer not defaulted. So there's a lot of money at stake. And again, just putting in 1 day due diligence gives that buyer that time they need to sort of catch their breath a little bit, regroup, and then choose if they do want to terminate or continue on with the contract. Let me point out where all of this is in your contracts. In the GAR purchase and sale agreement, the earnest money paragraph is in paragraphs A and B7, and the due diligence period, the number of days, is described in paragraph A8A, where the property is being sold subject to a due diligence period of blank number of days from binding agreement date. The description of what due diligence is all explained in paragraph B8. The default paragraph in the GAR purchase and sale agreement is all described in paragraph on the purchase and sale agreement C2, default, remedies for seller, and it is the earnest money and then rights of the broker, where it does explain that the broker does legally have the right to pursue that defaulting buyer for the commission. Now, in the RE forms, under the actual contract itself, which is RE 100, the buyer's general right to terminate is in paragraph 6.1. And it does talk about the number of days from what they term the acceptance date, which is the binding agreement date. And then in the standard terms, which is RE1, the contract is RE100, standard terms is RE1, it does describe what the buyer's right to terminate period is. And again, it's the exact same concept as the due diligence period. That is in the standard terms under paragraph 6. And it does talk about default and the remedies for default, again, being the earnest money to the seller and commission to the broker, and that is described in RE Form 1, the standard terms, paragraph 10. Now, the only exception to this about putting 0 days in due diligence is under the GAR purchase and sale agreement. If a buyer is purchasing a property not with a due diligence period, but rather with a property being sold with the right to request repairs, it's one or the other. Now, don't get it confused. If a buyer is purchasing a property with due diligence, again, that is a termination right for the buyer to terminate for any or no reason. One of the things a buyer will do to help them make the decision if they're going to terminate or not is have an inspection done. So that's not what I am talking about. What this is contractually not a due diligence period. The buyer does not have the right to terminate for any or no reason. Instead, the buyer is going in under contract with the seller, property sold with the right to request repairs exhibit. And that form is GAR F273. Again, this is mutually exclusive from a due diligence period. So if a buyer and a seller choose to go under contract with the property sold with right to request repairs, not a due diligence period, then in that situation, you would put 0 days for due diligence, or you would put in NA, because the due diligence period is not applicable if the buyer is using the Exhibit 273 under the Georgia Association of Realtors forms, property sold with right to request repairs. I've done several videos on this option rather than a buyer going under contract with a due diligence time frame. There is a time frame in this exhibit for the buyer to have an inspection done, send the seller a list of items, if they choose to, of actual defects with the property, along with the inspector's report. All of these terms are defined on this exhibit, and there is a specific amendment to remove this right to request repairs. Again, I've done a lot of other videos on that exact actual exhibit. Today, just wanted to talk about the third most dangerous line to leave blank in a purchase and sale agreement. Thank you guys so much for watching. Please watch those other two videos on why, or the danger of leaving a blank in the binding agreement date, and there's a lot of contractual explanation and something new in the Georgia Association of Realtors contracts for 2022. So you'll definitely want to make sure to check out that video, as well as the contingency timeframes, particularly appraisal and financing contingency timeframe. Does that mean that if you leave that line blank, does that mean that the contingency period goes through the length of the contract, or is 0? Check out that video for the answer. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.